Friends, today's topic is United Nations Declaration on the Right of Indigenous People 2007. The UN Declaration on the Rights of Indigenous People, or in short UNDRIP, was adopted by the UN General Assembly on 13 September 2007. It is so far the most comprehensive and advanced international document dealing with Indigenous people's rights, which is the outcome of the continuous effort of various individuals, state and non-state actors. For instance, the UN Charter, adopted in 1945, recognized the principle of equality of rights and self-determination of peoples. Similarly, the Genocide Convention, adopted in 1948, the Universal Declaration of Human Rights, adopted in 1948, the International Convention on the Elimination of All Forms of Racial Discrimination, adopted 1965, the International Covenant on Civil and Political Rights, and International Covenant on Economic, Social and Cultural Rights, adopted in 1966, reflects the same value and commitment. However, there was no separate mandate for the indigenous peoples in the UN system. They were taken under the wings of the International Labour Organization, in short ILO. The question of indigenous people at the UN was prioritized only in the early 70s, when the UN expert drew attention to the human rights problem faced by indigenous people. In addition, the indigenous people were struggling for their rights through the language of human rights. The most significant initiative was the approval of the study on racial discrimination at its 23rd session in the year 1970 by the UN Subcommission on Prevention of Discrimination and Protection of Minorities. Presently, it is called UN Subcommission on Promotion and Protection of Human Rights. During the discussion, various members of the subcommission supported the recommendation that the UN should conduct additional studies into the issues of the treatment of indigenous population. Subsequently, on 21st May 1971, ECOSOC unanimously approved and authorized the subcommission to conduct a study of problems of discrimination against indigenous population and to suggest necessary national and international measures. In this regard, the subcommission appointed Jose Ricardo Martinez Cobo as special rapporteur and requested a preliminary report on the matter to be presented to its 1972 session. The preliminary report was approved without any amendment by the subcommission. The international effort in strengthening the right of indigenous people gained significant momentum when the ECOSOC established the Working Group on Indigenous Population, in short WGIP, in the year 1982. It is a subsidiary organ of the Subcommission on the Promotion and Protection of Human Rights and meets annually in Geneva. The working group has twofold mandates. Number one, to review development pertaining to the promotion and protection of human rights and fundamental freedom of indigenous people. Number two, to give attention to the evolution of international standards concerning indigenous rights. The working group consists of independent experts and members of the subcommission, one from each of the geopolitical regions of the world. The working group is open to all representatives of the indigenous people and their communities and organizations. For the first time, indigenous people had access to their own UN forum, which became a World Forum for Indigenous Peoples Movement. The working group is today one of the largest UN forums in the field of human rights. The formulation of drafting UNDRIP first began in 1983 within the Working Group on Indigenous Population. For almost a decade, the working group devoted a large part of its time on drafting the text. The involvement of Indigenous people in the process was made possible through the establishment of the Voluntary Fund for Indigenous Population in the year 1985, with the purpose of assisting representatives of Indigenous communities and organizations to participate in the deliberation of the working group. In the year 1993, a draft UNDRIP was agreed and was approved by the subcommission in the year 1994. It was then forwarded for consideration to the UN Commission on Human Rights. In continuation to the process, a working group on the draft declaration was established in the year 1995, whose report was considered by the Commission on Human Rights. Further, an intersessional working group was established under the Commission on Human Rights with the mandate to consider the text presented and draw up a draft declaration for its consideration and adoption by the UN General Assembly. The establishment of United Nations Permanent Forum on Indigenous Issues, in short UNFII, in the year 2000 by the ECOSOC was another achievement. The UNPFII is an advisory body to ECOSOC with a mandate to discuss indigenous issues related to economic and social development, culture, environment, education, health and human rights. This was further strengthened by the establishment of the Special Rapporteur on the Rights of Indigenous People by the Commission on Human Rights. Now it is Human Rights Council. The Special Rapporteur has a mandate to inter alia examine ways and means of overcoming existing obstacles to the full and effective protection of the human rights of Indigenous people, to identify, exchange and promote best practices, and together request, receive and exchange information and communication from all relevant sources on alleged violation of their human rights and fundamental freedom, and to formulate recommendation and proposal on appropriate measures and activities to prevent and remedy violations. The Commission on Human Rights was replaced by the Human Rights Council on 26 June 2006 and subsequently adopt the revised text by a vote of 30 in favor, 2 against and 12 abstention. It was then submitted to the General Assembly for final approval. Unfortunately, at this stage, a number of states in the UN African Group withdrew their support for the draft. While not all the group initially agreed with the objection of some of its members, the group eventually agreed to act as a voting bloc in dealing with the draft declaration. It was only in early September that an agreement was reached between the state co-sponsor of the draft declaration and the African Group on 9 amendments to the text as adopted by the Human Rights Council. The Global Indigenous People Caucus Steering Committee on the draft declaration gave its approval to this amendment text, which was then put before the General Assembly. In December 2006, Namibia proposed a successful resolution deferring the vote on the draft declaration to the end of 61 session in September 2007. The historic day was on 13 September 2007 when the General Assembly adopted the amendment text as the Declaration on the Rights of Indigenous People by a majority of 144 states in favor, 4 votes against and 11 abstention. They are Azerbaijan, Bangladesh, Bhutan, Burundi, Colombia, Georgia, Kenya, Nigeria, Russian Federation, Samoa and Ukraine. The 4 countries, Australia, New Zealand, Canada and the United States, that initially refused to sign the UNDRIP shares very similar colonial histories and as a result have common concern. Its nation argued that the level of autonomy recognized for the indigenous people in the UNDRIP was problematic and will undermine the sovereignty of their own states, particularly in the context of land disputes and natural resource extraction. However, by the year 2009 and 2010, Australia, New Zealand, Canada and the United States reversed their position and now supports the UNDRIP. Indigenous peoples are recognized as being among the world's most vulnerable, disadvantaged and marginalized peoples. They constitute approximately 5% of the world population with a rough estimate of more than 370 million in some 90 countries. The adoption of UNDRIP is a process to address the situation of indigenous peoples. The declaration covered various aspects of indigenous peoples such as equality and non-discrimination, cultural integrity, collective rights, self-determination, autonomy, participation, consultation and consent, land, territories, resources, development with identity, and redress and compensation. The declaration is classified as A. Overarching principles, which is from Article 1 to 6, right to recognition of all existing human rights including non-discrimination, self-determination, autonomy and maintenance of indigenous institutions. B. Life, integrity and security, which is from Article 7 to 10, right to freedom from genocide, forced assimilation or destruction of indigenous culture or forced relocation from indigenous land and the right to integrity and security. C. Cultural, spiritual and linguistic identity, which is from Article 11 to 13, right to practice and revitalize indigenous culture and the transmission of histories, language, etc., and to the protection of tradition, sacred sites, ceremonial objects and repatriation of remains. D. Education, information and labor rights, which is from Article 14 to 17. Right to education including the right to indigenous educational institution and instruction in indigenous language. To have indigenous culture reflected in education and public information. To have access to the media, both mainstream and indigenous, and to be protected from economic exploitation. E. Participatory development and other economic and social rights, which is from Article 18 to 24. Right to participate in government decision making through representative bodies, to guarantee against violence and discrimination for women and children, to development and to access to traditional health practices and medicines. F. Land, territories and resources right, which is from Article 25 to 32. Rights to maintain traditional connection to land and territories, to redress for land that have been taken, to conservation and protection of the environment, to prevention of the storage of hazardous waste or military activities on indigenous land, to protection of traditional knowledge, cultural heritage and intellectual property, and to the fair procedure including the opportunity to give free, prior and informed consent in advance of any development on indigenous land. G. Indigenous institution, which is from Article 33 to 37, right to determine tribal membership and maintain tribal institutions including judicial system, to maintain relation across international borders, and to recognize treaties, agreements, and other constructive arrangements with the government. 8. Implementation of the declaration, which is from Article 38 to 46, requires the government and the UN agencies to implement the provision of the declaration by providing access to financial and technical assistance, providing conflict resolution processes that are just and fair. The adoption of UNDRIP is the most significant achievement in the history of indigenous people's rights. However, it is not the end of the movement, but the beginning of a new phase, where the movement has to be intensified to respect the declaration and to adopt into a legal binding instrument. The process of implementation will be the testimony of commitment to indigenous peoples by the UN system and its member states.